When talking about asset titling in estate planning, we mean making sure that your assets will flow the right way in the case of incapacity or death. Flowing the right way means that those assets will be received by the people that you want to receive them, oftentimes flowing into a trust, or they'll likely be owned by a trust and won't even need to flow into them. When I say flow into, I mean a beneficiary designation, like on life insurance. Once you pass away, the beneficiary lists where that should go. A lot of times when you have minor children, the beneficiary is a trust. When you have adult children, the beneficiary might be your adult children directly. It's a really nuanced issue, and we love to look at that one-on-one with our clients to make sure that we're giving the most tax-efficient advice and the best advice for your kids based on their needs and their ages. Asset titling is crucial for determining who owns your property after death and during incapacity. If you set up a trust and don't put your assets into the trust, it can be really tricky if you become incapacitated. If you don't get them moved in before you die, we may be going to court to have a probate proceeding to get those assets moved into your trust. So we can avoid a lot of all of that legal headache by properly titling your assets shortly after your estate plan is set up. Asset titling absolutely can avoid probate. We like to make sure your primary residence is owned by the trust and that any of your bank accounts, water rights, your vehicles even sometimes, depending on your state, the asset titling recommendations can vary based on state law. So make sure that you check with your attorney on how best to have your assets titled. Accounts in joint tenancy affect asset titling because the joint owner, whoever survives, receives that account and is the legal owner of that account. Sometimes people will list a child as a joint owner on an account and expect them to do the right thing after they pass away. Legally, that child that was a joint owner on the account doesn't have to give that money to the other siblings, let's say. It's better to put that account into a trust and to have the trust dictate where the account goes after death to avoid any concern or issues after you've passed away. There are a lot of tax implications with asset titling. Sometimes people will think, oh, in order to avoid probate, I will just gift my house to my children before I pass away. That's not the most tax efficient outcome. It's better to put the property into the trust and let your children inherit the property. They will pay a lot less in tax. Make sure that you have a comprehensive list of all of your assets when meeting with your estate planning attorney. They will be able to give you the best advice on how to title your assets and understand if there's tax issues that maybe need to be brought up or asset protection strategies as well. Being comprehensive and disclosing that information is crucial for us to give the best advice, and I highly recommend keeping a list of all the accounts and approximate values. If you have any questions about asset titling and why it's important, give us a call.